MSW Media.
So yeah, now it's clean up on aisle 45 time. And for a long while yet, it is going to be clean up on aisle 45.
Hey everybody, welcome to episode 256 of Clean Up on Aisle 45. It's Wednesday, December 17th. This year is almost over and it can't go fast enough.
Yeah, happy Wednesday, everybody.
Yeah, 2025 needs to GTFO. I'm just so sad about what happened with Rob Reiner and his wife and all these shootings this weekend. But, you know, we've got to do the news. We've got to cover the news. So, that's what we're going to do here on this Wednesday. I'm Allison Gill.
AAG. Yeah, truly heartbreaking what happened with that family, Rob's family. Truly heartbreaking. But yeah, we're going to press through and get through this news. And also what happened at Brown University.
Yeah, and in Australia. I mean, it's so much.
It's just like, wait, I'm forgetting one. It's a crazy thing to have to forget one of. Harry Dunn here. But today on Cleanup, we're going to cover the first day of the trial for Milwaukee Judge Hanna Dugan, as well as the government's new motion to dismiss the lawsuit brought by having to hang the January 6th plaque.
Yeah, and you can't talk too much about it, but we can read from the filing and we'll let everybody know what the government's argument is to dismiss this lawsuit. Yeah, and we have a new filing in the Hunter Biden Patrick Byrne saga, the old Overstock.com former CEO, and that defamation case. Plus, we have a CBS Special Report on a couple of guys named Danny Hodges and some guy named Harry Dunn. But first, we have new patrons to thank. So thank you to John Schoenthaler and somebody's mother. Thank you to somebody's mother. And our Hall of Famers, Maria Tovar, Ren Special K Kaido, Dr. David, Clover's Tree 73. Keep an eye out for Be More Goat, Baltimore Proud, Christine G. Passion, Alma Rennan, and Rose Flaherty. Thank you so very much for supporting us and supporting independent media. We couldn't do this without you. All right, we have so much to cover today. So let's kick this off with day one of Milwaukee Judge Hanna Dugan's trial. Our friend Adam Klasfeld at All Rise News was in the courtroom today. And already, Harry, it's not going well for the government.
Yeah, already.
Now, here's what Adam Klasfeld says. As the trial of Judge Hanna Dugan kicked off Monday, a federal prosecutor told a jury that arresting undocumented immigrants inside of a Milwaukee County Circuit Court building was routine. That was before Judge Dugan's clerk informed her that 5 ICE guys were waiting outside her courtroom on April 18th. Quote, then it was no longer business as usual. That's what Assistant U.S. Attorney Keith Alexander told the jury. He said, then it was no longer a routine day.
Yeah, Judge Dugan's prosecution has been seen as a dramatic escalation of Donald Trump's attacks on the judiciary in the name of immigration enforcement. The prosecution and defense accept that Dugan had strong views about the immigration arrests inside Milwaukee County Circuit Court, which judges of that court complained about frequently. Assistant U.S. Attorney Keith Alexander told jurors that those views are immaterial to her trial. She's on trial today because those strongly held views motivated her to cross the line, Alexander said.
God. Now, on this point, the attorneys agree that on April 18th, Judge Dugan was presiding over the case of Eduardo Flores Ruiz, an undocumented immigrant charged with domestic violence. 5 federal agents were waiting outside her courtroom to arrest Flores Ruiz based on an administrative warrant, not a judicial warrant. Dugan referred the agents to the chief judge of the courthouse for legal advice and then escorted Flores Ruiz and his public defender, Mercedes de la Cruz, through the jury door that led to a restricted hallway. Inside that hallway, one door led down a stairwell to an alternative exit, and a side door spilled into a public hallway roughly 10 feet from the main entrance of the courtroom. And prosecutors claim that Dugan intended for Flores Ruiz and his attorney to exit through the stairwell to evade arrest. But Dugan's defense team says she intended for them to leave where they actually exited, a public hallway where agents were waiting. Now, Dugan's attorney, Stephen Biskupik, said that prosecutors were also wrong about how allegedly routine immigration arrests inside the courthouses were. The practice sparked anger, confusion, and paranoia among judges inside the courthouse, according to Judge Dugan's lawyer.
Dugan's indictment said that she falsely told federal agents that an administrative warrant wasn't sufficient to effectuate the arrest. But her attorney told the jury that she correctly followed the chief judge's instructions on the law. In an email shown to the jury, the chief judge from Milwaukee County Circuit Court advised other judges inside the courthouse that an ICE warrant does not compel courthouse personnel to cooperate.
Oh, so Judge Dugan was just following what the chief judge said. Interesting. Now, during opening statements that lasted about 90 minutes, the jury heard audio recordings of conversations between Dugan and her court reporter. The two of them could be heard in hushed tones about how Flores Ruiz's attorney would exit the courtroom. She said, "I'll do it. I'll take that heat." That's what Dugan said. The prosecutor said it was unusual for judges to wear their robes outside the courtroom, but surveillance footage showed that Dugan kept hers on when confronting federal agents. Quote, "The judicial robes that the defendant wore that day do not put her above the law." That's what Assistant U.S. Attorney Alexander told the jury, turning a slogan used against Trump in his criminal cases on its head.
Splashing cold water on the prosecution's oratory, Dugan's defense said that the case was ultimately about 10 feet, 11 inches, the distance between the main entrance of her courtroom and the side entrance. Biskupic told the jurors that the distance is less than the length of the box where they are sitting, the jury box. U.S. District Judge Lynn Alderman said that the trial is expected to last 4 days. The government plans to call up to 25 witnesses, starting with FBI agent Aaron Lucker. The defense witness list is not yet known.
Yeah, Judge Dugan isn't sure if she's going to testify in her own defense yet. But on the stand, Aaron Lucker provided all the information about how investigators obtained the evidence so that she could get it all admitted. But on cross-examination, Harry, Dugan's lawyer, Biskupic, got her to admit some things that made the government's case look really bad.
Yeah.
First, Lucker admitted that the ICE agents in the hallway were not wearing anything on their uniforms that would indicate they were ICE agents. And that Flores Ruiz actually walked by two ICE agents sitting outside the courtroom when he exited from the private hallway, and that neither of them attempted to arrest Flores Ruiz when he walked right by them.
Interesting. Then Lucker admitted the federal agents used Signal to communicate, specifically a chat on Signal called Frozen Water Group. ICE, Frozen Water Group. And Lucker also admitted that there were contingency plans in place. But then Dugan's lawyer asked of Lucker if she knows what a routine day in the Milwaukee courthouse looks like. And she admitted she did not. That contradicts the premise of the government's opening statement that what Dugan did was not routine. How do you know what's routine if you don't know what a routine normal day looks like?
The lawyer was like, "Do you spend a lot of time as a federal agent in the state Milwaukee courthouse?" "No." "You've been here a lot?" "No." "Do you know what a routine day is?" "No." "Okay." Then how do you know she went outside the routine? It's not looking good. And currently, as we're recording this, there's more testimony going on. We'll have to go over that detail after it happens, because there's a little bit of time in between when we record this and when it goes to air. But, so far, Judge Dugan's attorney, Biskupic, who's a great attorney, is doing a really good job picking apart the prosecution and their case. She wore robes, but they won't protect her that day. Like, okay, just, I don't know. It's kind of cheesy.
It is. You could kind of tell sometimes during the opening arguments how a trial's going to go. But if that's any indication, it doesn't look good for the prosecution.
Yeah. Yeah. And there's some other stuff that's going on. Like, I'm looking at Adam Klasfeld's feed right now. Another witness is up right now saying that the administrative warrant that the judge signed listed the top charge against Eduardo Flores Ruiz was strangulation and suffocation. But on cross-exam, he says that he didn't know the defendant was even charged with that. So he actually faced 3 counts of misdemeanor battery. So, like, they don't even know what, they aren't prepared. It's
it just doesn't.
I think they might have a hard time convincing 12 people unanimously. And there was a lot of There was a lot of people outside the courthouse protesting, and free Judge Dugan and
Free Judge Dugan.
I mean, she's not in jail, but
25 witnesses, though, AG. Are they compensating for something?
Yeah. Lack of a case.
Lack of a case, calling 25 witnesses. And it's crazy. What a lot of people don't realize is the dude exited right out of a public entrance 10 feet away from the entrance in case, right? I mean, the entrance in question.
Yeah.
10 feet, 11 inches, the size of a jury box.
Yeah, smaller. Is it as big as a jury box? No. And, the fact that the chief judge actually put a memo out to the judges saying that an administrative warrant doesn't cut it.
They're just following orders, right? And that would that's what they like to say, just
right.
following orders.
I mean, that's what the chief judge instructed.
Yeah.
So I don't know, maybe you could sue him, but I don't think they've got a case here. But we'll keep following it, and make sure to follow Adam Klasfeld at All Rise News for the latest. He'll have more out, and there's probably already more that's come out, as we haven't even covered day 2 of the trial, which happened yesterday as you're listening to this. But we will cover it on next week's episode. All right, we've got more to get to, including your lawsuit, Harry, to hang the January 6th Plaque, and the government's really weird arguments about why your case should be dismissed and there should be summary judgment, including one argument that doesn't even fall within the 2 main arguments that they make in their introduction. I can't really follow their filing. Usually when you have a filing, they mention everything in the introduction and then they break it down on factual background, right? And I can't even really follow how how Judge Janine Pirro has put this together.
That makes maybe 2 of us, HE.
Maybe glug, glug, glug. I don't know if she was entirely sober when she wrote it, but we will talk about it right after this quick break. Stick around. We'll be right back.
All right, everybody, welcome back. All right, so we got an update for you in my lawsuit and Daniel Hodges to hang the January 6th Plaque. I can't discuss it much, obviously, because it's an ongoing matter, but Allison can discuss it, and Allison can cover the latest filing by the government in the case.
Yeah. The government filed a motion for summary judgment and to dismiss your lawsuit. The government says the plaintiffs are 2 current or former law enforcement officers. There's 2 of you. Why couldn't they say a current and a former? They're either current or former, and there's 2 of them. The government says that you allegedly responded to the incident at the Capitol on January 6, 2021. So it's only alleged that you were there.
Yikes. All right.
Now, the 2 of you allege a violation of the Equal Protection Clause of the Fifth Amendment for the alleged failure of the alleged architect of the Capitol to allegedly comply with the provisions of Public Law 117-103. I might have added a couple of extra alleges in there just because I'm being a jerk. But they say this complaint should be dismissed for several reasons. First, plaintiffs lack standing to challenge the architect's alleged noncompliance with the act, the law that says that they have to hang this thing. The alleged harms they identify in the complaint consist of psychic injuries compounded by the government's refusal to recognize their service, accusations by unidentified third parties that the plaintiffs were crisis actors or left-wing conspiracy agents, and the receipt of death threats from unidentified third parties.
Yeah, they go on to say these alleged intangible harms are not sufficiently concrete to constitute an injury in fact. Further, because these harms either allegedly arose from the events of January 6th or allegedly flow from the subsequent independent actions of third parties, they are not plausibly traceable to the architect's alleged failure to install the plaque called for by the act, nor would they be redressed by compliance with the act. The absence of standing requires dismissal of all plaintiffs' claims.
That's really interesting
Isn't it?
To actually argue that, hey, no one can ever be held accountable for third parties doing terrible things that they were encouraged to do by the person you're suing. It's like where? Wow. Okay.
Yeah.
Aside from the issue of standing, the government says plaintiffs also failed to plausibly plead a claim for relief. plaintiffs have failed to plead an equal protection claim because they have not plausibly alleged that no conceivable set of facts could legitimately explain the claimed disparate treatment that they allege from the architect's alleged delay in complying with the act. What? And plaintiff's mandamus claim fails because a claim for mandamus under Section 1361 is not available against the architect of the Capitol because it's part of the legislative branch. The mandamus statute only applies to the executive branch. And so those are their two main things. You failed on your standing, and your equal protection claim doesn't work because there's no set of facts that could explain the disparate treatment from the architect's delay, and that they can't, the court mandamus isn't available because the architect of the Capitol is not an employee of the United States, which is interesting. But here's where it gets weird. So those are their main thrusts, right? But then they bring in this other weird argument, and they don't attach it to any of those things. They say, as stated in the complaint, the architect testified before the Appropriations Subcommittee in April of 2025, and during that testimony, the status of the plaque was raised. The plaque referenced in that hearing, however, lists the names of approximately 21 law enforcement entities, not the approximate 3,648 individual names of law enforcement personnel provided to the architect. Thus, the plaque referenced in that testimony is not the plaque directed by the statute, which calls for the creation of a plaque listing the names of all of the officers of the Capitol Police, MPD, and other federal and state and local law enforcement agencies and protective entities who responded to the Capitol on January 6th, as reflected on a list to be provided to the architect. A physical plaque containing that list of names, 3,648 names, has not been made. But what's weird is that they put that, again, in the background, and it has nothing to do with whether you have standing or whether the court can issue a writ of mandamus against the architect because he's part of the legislative branch. It's just bizarre. It's a bizarre filing, Harry, and I'm interested to see how your lawyer responds. Because as far as I know, mandamus can apply to employees of the United States, which should include the architect.
Yeah, it's interesting. A lot of people don't realize the architect of the Capitol is appointed by the President of the United States. So that's how they get that. It's an appointment, a presidential appointment. But also in regards to how we respond to this, we're, obviously discussing, and I can assure you that it will be filed before Christmas time, which Christmas, December 25th. It will be filed before then. And we are coming with a response to this regarding to challenge their saying that we don't have standing, and that also that we have not suffered. The remedy of the plaque will not bring a healing, if you will, to what the word. It's careful. I got to be careful about how much I'm saying.
I think what you're getting at is that because they're arguing that if they hang the plaque, then that's not going to fix any harm.
Correct.
And
correct.
That there is no harm, but it will, and so that argument will be made. And I assume also your lawyer will argue about the fact that mandamus can be issued because this is somebody that's appointed by the president. We'll see. We'll see that argument, and we'll cover it here. And I will. You won't talk much about it.
But another thing, AG, just simply, if you look at the language out there, even coming from the President of the United States and members of Congress and people in powerful positions, they have downplayed January 6th as a tourist visit, a peaceful protest, a riot or it got out of hand. And those are just some of the things that it has been called by people that have downplayed it. But if you look at the language of the plaque, what it does is it clearly states that the officers who responded that day were heroes, in fact, and just served their country. And they were not crisis actors, and they and we were not crisis actors. So it kind of sets the record straight in legal forms because it is a law. The plaque actually is a act of Congress that is a law. So it just kind of sets the record straight. It helps solidify it when there's so much in this administration trying to downplay and rewrite the record of what happened that day. This kind of goes as a permanent fixture to set the record straight about what did happen that day.
Yeah, and there are hundreds of cases that went through the legal process. They're pardoned now, but insurrectionists who tried to argue, I was just swept up in the day. It wasn't, I just got swept away by the excitement or whatever, and I was only doing what Donald Trump told me to do, and judge after judge after judge was like, that is not a defense, and so it shouldn't be here either. And I'm looking forward to see how your lawyer responds. But speaking
stay tuned, it's coming.
But speaking of Harry Dunn and Danny Hodges, CBS did a story on y'all, and I want to cover that. But we have to take a quick break, so everybody stick around. We'll be right back. Hey, everybody, welcome back. So CBS did a story on a couple of guys named Harry Dunn and Danny Hodges. Danny Hodges thinks of himself as an introvert. He's soft-spoken, and he says he's averse to the spotlight. At night, he's a local police officer in Washington, D.C., but during his off-duty hours this year, Hodges has become a unique and very public advocate on Capitol Hill. He told CBS News he's trying to be a firewall to block the whitewashing of the history of the January 6, 2021 U.S. Capitol siege. Quote, the only thing that will stop me is if people stop lying about January 6th and just acknowledge what the day was and what really transpired. That's what Danny said. He was among, as we know, one of the more than 140 police officers injured while trying to stop the U.S. Capitol insurrection.
With Republicans now in control of the White House and Congress, and some in the party downplaying the severity of the Capitol attack, there are limited platforms for victims of the attack to talk about its impact on their lives, our lives. Hodges has become a go-to witness for Democrats in congressional hearings about police safety.
Yeah, because the Republicans want to talk about safety for ICE officers, but no one else.
Yeah.
The mission generates some stress and conflict for Hodges. At an October subcommittee hearing in the Senate, Hodges watched as 3 of his fellow witnesses raised their hands when asked if they supported Trump's pardons of the January 6th attackers, including those who had beaten Hodges. One of the witnesses who raised his hand was former Homeland Security Secretary during Trump's first term. As the minority in the House and the Senate, Democrats are permitted to call one witness at most hearings to serve as the minority party witness who provides a counterpoint to the witnesses called by the majority. Twice this fall, Democrats have called on Danny Hodges.
Funny story, real quick. This is not in the article, but Danny and I actually paper, rock, scissors to see which one of us was going to testify. Since we only can call one witness, the Democrats can only call one. So one of those, fortunately, I'm glad to have been there with him. But the power of Daniel Hodges' narrative comes from the self-control he displays, said Peter Welch, senator from Vermont, who was the ranking Democrat on the Senate Judiciary Committee that called Hodges to testify in October. Welch said Hodges erased any of the legitimate anger he may have had about January 6th to just tell us what has happened during the hearing. Democrats argue Hodges' testimony and the presence at congressional hearings underscore the hypocrisy of Trump supporters who are making public statements in support of tougher laws or policies to protect police. At the same time, they're downplaying the attacks on law enforcement officers on January 6th.
Yeah. Now, Welch, the Vermont Senator Welch, noted that Republicans declined to ask Hodges any questions or speak to him in the hearing room after the testimony because they're chicken shits.
Yeah.
Quote, you do have to do an immense amount of intellectual and emotional jujitsu to pretend you didn't hear what Hodges said or acknowledge the reality of what he experienced. That's what the senator said from Vermont. At a December 3rd hearing convened by the House Homeland Security Committee titled When Badges Become Targets, How Anti-Law Enforcement Rhetoric Fuels Violence Against Officers, Danny Hodges testified that Trump's mass pardon of more than 1,500 Capitol riot defendants emboldens and encourages further violence against police.
Yeah, the press release announcing this hearing made it sound like certain participants were going to spend a few hours scratching their heads and pretending to not understand why threats against law enforcement have risen so sharply this year. And I cannot abide such a farce Hodges said in his opening statement. It was really good. It was really good. So if anybody has the opportunity to go read it, the full transcript is available on their website. Representative Benny Thompson, a Mississippi Democrat who called Hodges as a witness for the hearing, said he did so to combat pervasive misinformation.
Yeah. And Benny Thompson told CBS, everybody saw January 6th with their own eyes, but Trump has convinced a large percentage of the population that those were not insurrectionists. At an October hearing in the Senate titled Politically Violent Attacks, a Threat to Our Constitutional Order, Hodges was the sole witness called by Democrats. Quote, I am intimately familiar with political violence, as when I fought to defend the U.S. Capitol and many of your very lives. I was beaten, bloodied, and crushed, with my eye gouged and skull smashed with my own baton. That's what Danny testified. He criticized Republicans on the panel for not acknowledging the Capitol riot, telling them, my colleagues were under attack by a mob.
Hodges said the Republican members of the panel did not ask him questions about January 6th during the public hearings of the committees, nor did they thank him after the proceedings. Spokespeople for the Republican chairman of the panels at which Hodges has testified this year did not respond to CBS News requests for comments about Hodges' testimony. Hodges spoke with CBS News as a private citizen, not as a representative. This is always important to say because as law enforcement officers, and if you notice, Daniel Hodges, and when I was still an officer and Sergeant Cannell was too, when we spoke, we'd always have to say we're speaking as a private citizen, not as a representative of our respective police departments, because that was the fine line we had to juggle between our First Amendment right to speak out and also speaking on behalf of the departments we worked for.
Yeah. Now, he had testified previously before a national audience in 2021 at a public hearing for the House January 6th Select Committee, which investigated the causes of the impact of the insurrection. Trump's victory in 2024 and his first-day pardons of riot defendants have triggered criticisms of the administration that it is ignoring or rewriting the history of the siege.
Yeah, and in issuing the clemency of Capitol riot defendants, the White House said the president's decision ends a grave national injustice that has been perpetrated upon the American people over the last 4 years and begins a process of national reconciliation. Y'all press rewind and go listen to that again. Hodges acknowledged he also has received threats and menacing amid his public statements.
Yep, and former Capitol Police Officer Harry Dunn, who has attended some congressional hearings to support Danny, told
all of them.
told CBS News, Danny has been unwavering and cleared every obstacle he faced while continuing to serve. Dunn, who also testified and appeared at hearings of the House January 6th Select Committee in 2021 and 2022, said, with his good friend Allison Gill, said, Danny's and my mission has been the same. We're seeking accountability and justice against those who are responsible for the worst day of our lives. Hodges told CBS News, by the way, it will be impossible to convince all Americans about the truth of the impact of January 6th on the police victims. When asked if he's optimistic that the deniers of the violence of the siege will change their minds, Hodges paused for a second and then said, there are still people out there who think the moon landing was fake and that the Holocaust wasn't real. So you're not going to get 100%.
Well, I mean, he's right there. You're not going to get 100%. I want to read my entire comment for Danny. Scott McFarland is great, but I wanted him to include the whole thing. But our listeners are going to get to hear the whole thing of what I had to say about Danny Hodges. And Scott McFarland messaged me and asked me, can he get a quote? So I texted him back. I said, a lot of times in law enforcement, the term brother is thrown around because members are usually fighting for the same goal and mission. And that's to make sure everybody goes home safely at the end of our shifts. Ever since January 6th, Danny's and my mission has been the same. And that's been to seek accountability and justice against those who were responsible for the worst days of our lives. Danny has been unwavering and cleared every obstacle he's faced while continuing to serve, as he is the only remaining officer still serving from the four of us who testified. I'm thankful to call him not only my friend, but my brother. So shout out to Daniel Hodges right there, my friends.
Shout out to a great statement. I wish he would have printed the whole thing.
I'm sure he was on a word count.
Yeah. I mean, I people have asked me for quotes, and I've given them, a paragraph, and they just say, Allison says, "Yay!"
Yeah, I'm like, wait, that said so much more than that.
Anyway, yeah. And it's the two of you that are suing to put the plaque up. So
yeah.
But I remember those days. I remember, you inviting me to the January 6th hearings, and we all sat right there in the front row together and watched with our own eyes.
Do you remember how you felt, AG, though? Do you remember how you felt, and everybody else out there listening, we were front and center, but we felt, I did, that accountability was coming somewhere. Mm-hmm. Like those January 6th hearings, they were powerful. They were eye-opening. They were revealing. And I just knew that accountability was coming. And it obviously still isn't here. But
it felt like it. I remember when you testified before, because the bulk of the January 6th hearings took place that summer, but you had testified at the end of 2021, the four of you.
Yeah.
And, when they asked you, what do you want? You were like, I want accountability. I want justice for this. And we thought we were going to get it until the Supreme Court stepped in.
Yeah.
Twice. Once to say that the Section 3 of the 14th Amendment doesn't count for Donald Trump, that, the insurrectionist can't hold office again. And two, when they granted him immunity and ultimately delayed the trial that had been set for March.
Yep. Yeah.
March. Yeah. Yep. Very, very frustrating. So that's all you can do now is exactly what y'all are doing.
Yeah, that's it. That's all we can do. And we will continue to do is show up. So
yeah, and we appreciate you for it. All right, everybody, we got another update for you. Not on Rudy. No Rudy news this week.
No Rudy news.
But we've got something on. Wow, the man, the myth, the legend, the idiot, Patrick Byrne, former Overstock.com CEO, right after this break. Stick around. We'll be right back.
All right, everybody, welcome back. All right, so there's no Rudy news this week, probably for the best. Just go away, Rudy. But we do have a new filing in the Hunter Biden-Patrick Byrne saga. Law and Crime reports that as the years-long legal battle between former presidential son Hunter Biden and one-time Overstock CEO Patrick Byrne limps toward a likely determinative, if not entirely final, hearing early next year, a recent filing aims to clarify matters of the judge overseeing the case.
Yeah, so Hunter Biden's filed another thing saying he's still defaming me. On Friday, in a 4-page supplement to his default motion, this is the one where he's asking for $33.3 million, the default motion. He supplemented that a few days ago in a 4-page filing. Hunter Biden accuses Byrne of ongoing defamation. In the filing, Biden says, to inform the court of recent public statements allegedly made by Byrne, repeating the same defamatory statements on a widely distributed public forum that are the basis of this lawsuit. The continued public dissemination of these defamatory statements after the court stated in its order denying the defendant's summary judgment that defendant did not have a basis for making the defamatory statements shows that the defendant will continue to defame the plaintiff unless he's punished by the imposition of a significant punitive damages fine as requested in the plaintiff's default judgment motion.
Yeah, Byrne allegedly made the statements at issue during 2 December appearances on an eponymous program hosted by right-wing conspiracy theorist Alex Jones, The Alex Jones Show, and one of Jones's affiliated InfoWars talk shows, War Room Live. The supplement takes stock of promotions for the online broadcasts.
Yep, and here's a quote from the filing. A Twitter account attributed to Alex Jones posted the full 14-minute clip of the defendant's interview with the caption, "Breaking exclusive. Hunter Biden solicited an $800 million bribe from Iran in exchange for his father, Joe Biden, to unfreeze $8 billion in frozen Iranian assets. CIA whistleblower Patrick Byrne tells Alex Jones in this bombshell report, this is the defamation." To bolster his claim, Byrne has released one of many exclusive audio tapes in his possession. That's a hell of a title. Okay.
That is.
In the full clip posted by Alex Jones on December 9th, that's last week, not only does the defendant reiterate the same defamatory statements at issue in this matter, but he doubles down on them by taunting the plaintiff about this lawsuit and publicly states he harbors malice toward Hunter Biden. That's what the supplement says.
Yeah, trial in the case has been delayed multiple times. We've covered all those delays that going back into this summer when we started talking about this. After originally being slated for December 2024, the trial was pushed back to this past summer on a motion to continue filed by Byrne. Then in July, the trial was pushed back to October after a false start where Byrne suddenly fired his lawyers and failed to convince the judge to grant another attorney, pro hoc vice, permission to represent him instead. Then the jury trial was once again pushed back, this time January 2026. Around the same time, the court entered a default against Byrne, essentially a formality required before Biden can be awarded a default judgment.
Yep, and now Biden says that Byrne is even talking about the litigation delays in a way that makes him, Hunter Biden, look responsible. Quote, defendant even claims plaintiff is scared to face him in court. Byrne is the one who's gotten all these, he won't show up and has asked for all the delays. Yeah. But now he's claiming that Hunter Biden is scared to face him in court about these allegations, despite plaintiff being ready to proceed to trial last July with plaintiff present every day in the courtroom, all the defendant's misconduct in delaying the trial, failure to appear at all, and then intentionally ignoring the court's orders led to a default being entered against him as a sanction. Now, Biden goes on to allege that Byrne violated a protective order in the case by playing a voicemail in one of the broadcasts. You can't do this. If there's a protective order against discovery, you can't tell anyone about it. Quote, defendant has intentionally violated the stipulated protective order. Defendant has again shown he has no intention of obeying the orders of this court.
The republication of the defamatory statements, along with a highly confidential recording years after the defamatory statements were first published and during the pendency of this matter, demonstrates defendant is a recidivist who will continue to maliciously attack plaintiff with false statements, the supplement goes on. Nothing short of a harsh punitive damage award will be effective in curbing defendant's ongoing defamatory conduct against plaintiff and outright disregard for this court's orders.
Yeah, the judge isn't going to be very happy about that, violating the protective order, by the way. And in a footnote, Biden likens Byrne's alleged behavior to that of Trump with regard to his repeat defamation of E. Jean Carroll, violations that have resulted in tens of millions of dollars in liability in New York state courts, $83.3 million and another $5 million plus interest. Considering that the defendant has continued to defame the plaintiff with the same false statements at issue in this case is comparable to E. Jean Carroll's case against Trump. In the first case, Ms. Carroll was awarded $5 million for defamation resulting from Trump stating she lied about being sexually assaulted by him. Following that judgment, President Trump made the same defamatory statement for which he was previously found liable, and at the second trial, Ms. Carroll was awarded additional damages, including $65 million in punitive damages alone, a 13 times increase in damages from the first trial. So,
yeah, give Hunter his money.
Patrick Byrne was already in trouble, but now he's redefaming and playing evidence that is under a protective order.
Yeah.
A discovery protective. Oh, man. I'm interested to see what the judge has got to be like, God damn it. What else?
I know. Here we go again. Judge, you are on the clock. This judge is on the clock. I can't wait I can't wait to see what comes out of this.
Even Rudy Giuliani shut up when Ruby Freeman and Shay Moss were suing him. Like, he stopped defaming them after a minute, but like, it's just, and it's the same lie. Like, make up a new one at least so you can't get in trouble.
Yeah, exactly. Do something different. Yeah, just not repeating the defamation.
Yeah, that $800 million. Wow, jeez. I mean, come on. Anyway, that's our show. And it's been a real hard weekend. It's been a real hard last 7 days. And so I just want to let everybody know that, we see you. We know it's tough. And I hope that everybody gets a little bit of a reprieve going into the holiday season and that we can start again fresh in the new year, with the news. Now, we'll be back in your ears next week, and we're going to do a patron happy hour before the holidays.
We are.
Which I think is this Friday. So if you're a patron, you want to check your junk, check your email
Check
for
your
that
junk.
link. Or this Thursday, maybe. I think it's this Thursday. I think
Is
we're
it
switching
Thursday?
it to
Okay.
Thursday.
Yes.
So I just want to acknowledge that it's been a tough weekend, a tough week. I mean, they've all been really tough, but it was especially bad with the news. So just wanted to acknowledge that and thank you again for listening, because I know everyone's pretty exhausted.
It's been a lot. So, but we have to know what's going on. So you just need to be aware. It just makes us, I think, more enlightened, educated individuals, which this show's audience is absolutely enlightened, engaged.
Definitely. All right, everybody. If you're a patron, we'll see you this weekend for the bonus, and everybody else, we'll see you next week for the public episode. Thanks so much for listening. I'm Allison Gill.
Harry Dunn. Thanks, y'all.
Cleanup on Aisle 45 is written, researched, and produced by Allison Gill, with editing by Molly Hockey. Our art and logo design are by Joelle Reeder and Moxie Design Studios, and our music is composed and performed by Adam Orr. Cleanup on Aisle 45 is a proud member of the MSW Media Network, a collection of creator-owned podcasts dedicated to news, politics, and justice. For more information, visit mswmedia.com. MSW Media.